with Judge Vonda B podcast. We will be talking today about Florida law with custody. All right. Don't forget to like, share, and subscribe to our YouTube channel. Let's get into it. Attorney Coleman.
Yes.
You're back with us.
I'm back. Thank you for having me back.
Of course. Thank you for being here. Now, this is the fun stuff, right?
The good stuff.
The good stuff.
The
Okay.
juicy details. Yes, ma'am.
Okay, because it's the same here in Texas. When we're talking about custody, it gets really juicy. You're talking about drama. Sometimes people fight, physically fight.
Yes, I've had that happen.
Yeah. So that's happened to you too in court?
In court,
Me
yeah.
too. Oh my gosh, that happened to me. I saw a fight in court as well as in the hallway.
That's usually where the drama goes down, definitely outside in the hallway.
Oh yeah.
But Florida tries to do a good job at separating the petitioner and the respondent before you get in the courtroom. But sometimes things happen.
Really? Tell me about that, because in Texas courts, when you go into court, everyone walks in together. The only time you see where one will come in before the other or one will leave before the other person is when it's a situation of domestic violence.
Yes. That's typically how it works for us too, but sometimes you can kind of give the court a heads up that the parties, are not really co-parenting well or doing well. So if you do need additional precautions, they'll make sure to take that for you.
Wow, that is interesting. They're not doing that in Dallas County, for sure.
Yeah, I do a lot of things different out here in Texas.
Yeah, especially related to custody, right?
Yes. Even with that word, so custody, Florida, we don't use that at all. For the purposes of this podcast, I will use that term, but in Florida, we deem it time sharing.
Time sharing, okay.
And visitation.
Time sharing and visitation. That's interesting, because we do not use time sharing at all in Texas. And honestly, I don't think we really use custody. We use it kind of loosely as, legal practitioners, but for the most part, you say conservatorship.
Okay.
So you have a primary conservator and a sole managing conservator, something like that. But time sharing is a new one.
Yeah, Florida was trying to take away the stigma of custody and making it seem as if children were property of some sort. So they try to just make it a little more gentle. Time sharing.
I like that. I actually like that.
I feel like Florida's actually, minus some crazy stuff, they're pretty progressive when it comes to making sure that kids are handled in a gentle manner.
Let me make a note of that. Tell the Texas legislators use the word time sharing.
Yes. Doesn't it sound gentle?
This is a major legal point that catches a lot of fathers off guard. In many states, when parents aren't married, the father doesn't automatically have legal parental rights, even if everyone knows he's the dad. Legally, he often has to establish paternity first before courts will recognize custody or visitation rights. That's why attorneys constantly stress filing a paternity action early. Without that legal step, a father could be paying child support but still have zero decision-making authority. So let me ask you, do you think that system is fair, or should both parents automatically have rights regardless of marriage?
It does sound gentle, and it kind of kills the conflict.
Yes.
Because custody sounds so, give me that,
Property.
It belongs to me. Yeah.
Exactly.
I like that. So let's talk about time sharing.
Yes.
What is time sharing?
So essentially it is what you would think of, custody, but it's basically where the child is going to be throughout all the days of the year. So in Florida, it's very meticulous. We want to know how many overnights a child is spending with each parent, what we're doing for holidays, what we're doing for birthdays, the parents' birthdays, Mother and Father's Day, things of that nature. So we want to know where the child is at all times.
You mentioned parent birthdays. That's a thing in Florida?
That is a big thing in Florida.
Really?
Yes.
That's a big thing that goes in a court order.
Oh yes, that is on the standard. If you went to a default parenting plan, the parents' birthdays are going to be on there as well.
Wow.
Because you'll have, certain parents playing tit for tat, and they'll try, if it's their weekend to have the child and maybe dad's birthday falls on that weekend, dad doesn't have to ask, may I have my child on my birthday? That's pretty much a default. And for Father's Day and Mother's Day as well.
Oh my goodness. Now, Father's Day and Mother's Day, we have that. That's embedded into the court order. But
well, that's a holiday. That's a holiday for people. So
the parent's birthday. Now, we do have the child's birthday.
Yes.
But the parent birthday, that is really throwing me for a loop right now, Because I've seen orders that includes the parents' birthdays, but that's only by agreement. That's not something that's standard in a Texas court order.
Right. No, I mean, because parents' birthdays are equally as important as a child's birthday.
I agree with you. If someone from the Texas legislature is watching this, include some parent birthdays in these court orders. That's a big deal.
It is. And, you know, I'm not a parent, I am an aunt, but what I'm learning from my friends that are parents is they want to have their kids with them on their birthday. They want to celebrate. Now, maybe nighttime, they might not necessarily want to have, you know, because you want to be grown, but on their actual birthday, they want to celebrate with their kids.
Oh, wow. Well, I can't say that that's for me.
Okay,
Even during the day. I can't say I want to have my kids during the day on my birthday.
That's fair.
But for some parents, I can see how that, especially a first-time parent.
Yes. That's where I see it a lot.
Yeah, first-time parent, their child is a little younger. Yeah, I guess back then I did, but
And
now
if we're
not so
talking
much.
right, and if we're talking about a co-parenting situation where both parents aren't in the home, then yeah, you might want to have your baby with you, you know, to celebrate that day.
Okay.
Because you know you might not see them the next day. They might be with the other parent, or you might not have them for the full weekend. You just have them for that day. So yeah.
Okay. Well, I like that. I like that. So they go to court, they're separated. Let's talk about the differences in custody when two people are married versus non-married.
Right. So in Florida, if you have children and you're married, both parents have equal rights off bat. If you have a child and you're not married, mom has all the rights in Florida.
Wait a minute, let me make sure I follow you. So a married couple, father and mother, or same-sex couple.
Yes. Mm-hmm.
Same difference, right?
Right.
So they automatically have rights?
If a child is born in a marriage, both parents are in equal standing.
So they don't need a court order?
No, if they're going through a divorce, then yeah, you're going to have a court order with the parenting plan.
Right.
But say, for instance, there was a child that was not born of a marriage. Mom can pick up and move, go wherever she wants to go, doesn't have to involve dad at all. Now, if you guys were listening to the first podcast episode, you do have Department of Revenue, right? So dad may be paying child support and have no rights to the child at all. So mom's getting money, but she can go live wherever she wants to live and doesn't have to answer to dad at all.
This is interesting. Interesting. Because, I mean, I guess I can see that. It works somewhat like that in Texas. Fathers have to have their rights actually placed in a court order.
Exactly. So that's what would happen, is you would file a case called a petition for paternity and related relief.
Okay.
So the paternity is what you're establishing, and the related relief are your rights.
And do you have to establish paternity in Florida before you can get that court order with your rights?
Yes.
That's a requirement?
Yes. I mean, if you have a good co-parenting mom that doesn't really want to get the courts involved, cool. But if you are in fear that mom might move or mom might withhold the child from you, then your best bet is to open a paternity case.
Okay. So here in Texas, if someone is court ordered to appear in court and they don't appear and they're supposed to get a DNA test, they don't show up or anything like that. They just get served and go on about their business. Can they be defaulted and named as the father?
So the courts try to stay away from those type of situations, but yes, as long as they were served properly, then yeah, you can get a default in Florida.
Okay, so it works the same way here in Texas as well. Okay.
But when it comes to the paternity side, I've not really handled any default cases because dads are pretty participatory when it comes to that. Now, on the Department of Revenue side, when they're served with child support paperwork, not giving them any rights, I do see a lot of times that there are default orders that are entered because people just don't participate. They feel like they're just being taken to court for money. They don't have any true rights, so they don't care.
All right. Now let's talk about court orders in Florida. And I don't mean to do like a comparison of Texas and Florida, but you're educating not only the viewers here, but you're educating me as well because I don't know anything about Florida law. So in divorce decrees in Texas, we have certain clauses. We call it the morality clause. It pretty much says that if you're going through a divorce, the divorce is pending, while the children are with you, you cannot have like a new boo or anything that stays at the house from the hours of 8 p.m. to 8 a.m.
That's y'all's default? That automatically goes into any order?
Well, I wouldn't necessarily say it's automatic, but if one of the parties asks for it or the judge orders it, it goes into the order?
I've honestly never seen that. I don't believe that we have it. If we do have that, that must be a law that's on the books and not really in practice. That's wild.
Yeah.
A morality clause. I've never seen anything like that. Because morals to me kind of feels like churchy almost. And you know, Florida's really heavy on the separation of church and state. I know Texas is a little different, so.
Well, you know, you said Florida on the first episode of, you know,
We're
right?
wild. Yes, we are wild.
Texas has some wild ways too.
Okay. Well, obviously for that to be a law, it had to have been a problem at first in order for somebody to say, hey, stop doing this. So
I wouldn't necessarily call it a law. It's just something that, I mean, I really don't know what the Texas legislator was thinking there. Maybe it has something to do with morally, when you want another person around your child when you're technically still married to your spouse.
right.
I guess it makes sense.
It does. I know that that is a concern when you have divorce cases, and a lot of clients do feel the other party might have a significant other or somebody who they're going to move on to shortly after. I mean, I handled a divorce one time. We had a final judgment on Friday. Saturday, he was getting married to somebody else.
Wait a minute.
Yes, very. Well, my gosh.
Is that legal
Yes.
in Florida?
If he's divorced and you get married the next day, yeah.
Here's another Texas difference. After you're divorced in Texas, you cannot remarry for 30 days.
Excuse me? See, this is
Wow,
crazy.
right?
Yeah. No,
Yeah.
that's crazy.
You cannot get remarried that fast. No.
I got invited to the it was my client. I got invited to the wedding. I was handling it with another attorney as well, because she wanted to get some experience with family law, but I didn't go to the wedding, but I was like, man, this is crazy.
Wow. The next day.
The next day, that Saturday.
Ooh. Okay, Florida.
But I didn't know you
see
guys had a
Florida.
waiting period. Do y'all have
Oh,
a
yeah.
waiting period to file for divorce as well? I know some states, you have to be separated for a certain amount of time first before you can file.
In Texas, after you have filed for divorce, that filing has to be on the court's record for at least 60 days before you can get a divorce. Now, that's not to say that everyone gets divorced in 60 days. We know better, right? But it has to at least have been, you know, on the books for that length of time.
Do you guys have a simplified divorce system here?
Not really.
Are you kidding me?
No, I am so
We
serious.
have simplified divorces in Florida because people want to be done. You
Well,
hear
they
me?
have annulments. Let me say
No,
that.
we're talking about a full-on divorce, not
Oh,
where you're
no.
saying something happened and the divorce or the marriage was never legit. No, I mean, you see what's going on with Tom Brady and Giselle. Florida does not play. When you are ready to be done with the person, you can be done.
Oh no, it's not like that in Texas, because in addition to that 60 days that I mentioned, you can get around that 60 days. So if domestic violence
Okay.
has been an issue, you can ask for a waiver of the waiting period, and then you can get divorced right away. But absent anything like that, you have to wait 60 days. It is statutory.
No, see, now I thought people should move to Texas, maybe just for child support. But if you want to get a divorce, move to Florida, because you can be done really quick. The only thing that I've seen that slowed down the case is one time a party asked if they could do counseling or something, and so the courts, you know, they want people to remain married. If you can work it out, work it out.
Right.
But you know, that was it. If the other party didn't want it, it's no waiting period. You go for it. Now, the slowdown sometimes happens if there's children, you know, of course, because the courts want to make sure the child support is calculated, that there's
Right.
the parenting plan in place. But if it's just two people that are ready to be done, no kids, especially no property, that can be done fairly quickly.
Interesting.
You have a whole different system that you go through, simplified versus
I see you, Florida.
right.
I see you. That's really different from Texas. But there is some overlap with some things, because you all have specialty language that you put in your court orders for
Yes.
divorce cases. Like I mentioned, the morality clause. What are some examples that you all do?
So one thing that's really important for me as an attorney is if the parties were married, or even if they weren't, I don't want a child to call another significant other mom or dad. So mom is mom, dad is dad, and any derivative of that word belongs to the biological parents.
Okay. You all put that in order?
Yes, we do, because it gets pretty bad. And you know, Florida, we have different languages. So we talking about if you calling somebody dad, if you calling them papi, that's the same thing. No, it's no derivative at all of that father or mother word.
Wow. Is that a rule? Well, like I said, it's not really a law. The morality clause is not really a law. It's more so just thinking about a divorce. I guess trying to protect what's left of the sacredness of the divorce, right? Between the people.
Exactly.
The parties, the parents, and the children. Is that the rationale behind it as well, with not using mom or dad?
It's not necessarily a law, it's just respect. And so if I see as an attorney, my client is coming in saying that they're bringing around another partner, and that the child is referring to that partner as mom or dad, and my client feels disrespected, we're not gonna have that. That's not fair, because you're putting up a wall and separating a child from the other parent, essentially, when you're allowing.
This is a major legal point that catches a lot of fathers off guard. In many states, when parents aren't married, the father doesn't automatically have legal parental rights, even if everyone knows he's the dad. Legally, he often has to establish paternity first before courts will recognize custody or visitation rights. That's why attorneys constantly stress filing a paternity action early. Without that legal step, a father could be paying child support but still have zero decision-making authority. So let me ask you, do you think that system is fair, or should both parents automatically have rights regardless of marriage?
On that language to be used for somebody else.
Alienation.
There we go.
Parental alienation. All right. Now let me ask you a question about that. How can you enforce that?
It's easy to be enforced. A child will tell you what they're calling somebody else.
You all interview children like that in Florida?
If my client is telling me that, I might not insert a child into the case just for that alone. Typically, if somebody's being disrespectful like that, it's other things happening as well. So if a child does need to be involved in a case, of course, we have to ask the judge for permission with that. But if we already have that language in our final judgment, it knocks it out. People are not going to really play with that because judges don't play about it. But yeah, if you're asking about evidence, I mean, there are other ways, you can get video of a child maybe doing that, text messages of a child doing that. A lot of times the parent will tell on themselves. Oh, you're not a good dad. That's why so-and-so is a better father than you were anyway. She thinks that's her dad. You know what I'm saying? That parent will give you enough evidence if that's the type of person they are.
Oh, wow. And you've seen that?
I've seen it and I hate it.
It sounds so hurtful.
It's done on purpose because, like you mentioned in the previous podcast, sometimes people want to just kind of move on with their life and they don't want the other parent to be involved. You know what I'm saying? So they'll do little things like that to go tit for tat with the other parent, and like you said, parental alienation, block that child from having a good relationship with the other parent. And the child becomes confused. You have one mom, you have one dad, or you have two mommies or two daddies. Don't give that title to anybody else.
That makes sense to me. Yeah. Maybe we should, let me make a note of that. Texas need to add, what is it called, mommy daddy clause?
I would say that, yeah.
Okay.
Listen, sometimes when you're an attorney, you got to make up your own language for stuff.
And we do that a lot.
So if that's what you want to call it, a mommy daddy clause, go for it.
Okay, all right. Any other interesting order languages that are in Florida, orders that we may not have in Texas that you can think of?
I'm not sure, but I'm learning a lot when you're saying things like slowing down the divorce and whatnot. So if something comes up, I'll let you know. But yeah, that's the only thing I can think of right now.
In the previous podcast, you mentioned you represent a lot of fathers. What about you stands out that people should hire you over someone else for the representation of a father?
I actually care. For me, I know a lot of attorneys do billable hours. For me, I charge flat rates. Meaning that you know what the entirety of your case is going to cost, and you are able to, do a payment plan for that. But more importantly than the money, I actually care. I want to get to know you as a person. I want to get to know your child as well. Do you know who your child's doctors are, their teachers? All of those things are very important, so I make sure that a dad is prepped and ready to go to trial or ready to go to mediation, whatever it is, but I ultimately care. One thing I see a lot of attorneys leaving out when they go to trial is, what is this child like? What's their favorite color? Who are their friends? They forget that these babies are humans and they have likes and dislikes. So I want to get to know that child, even though a lot of times I don't even meet the children, but I'll get updates on them. I have a divorce case that Listen, I thought I was going to quit law over because it was crazy, a military divorce case. But I get updates. I've been invited to cookouts. I finally got to meet that baby, and to see her go from, you know, where she was when I first got onto the case to now is just amazing. So I care. And if you're looking for an attorney that does care about your case and is not just, you know, trying to collect the check, then that's why you would want to hire me.
Thank you for putting that ending on there, because I was just getting ready to say, let the people know where they can find you. Like, what is your contact information, your website, your social media handles? Let everybody know.
Yeah, so my phone number is 407-801-9533. I can be contacted via email at Kai, so CAI, at colemanlaw.net, and my website is colemanlaw.net.
All right. Thank you for that. I wanted to move over to the time sharing. These court orders, they can either be ruled upon by the judge themselves, or the parents can agree to their time sharing agreement or something like that, right? Okay.
So for Florida, mediation is mandatory before you can go to trial.
Wait. What now?
It is mandatory.
So that doesn't really happen here. In some counties, I know I have a lot of friends that practice law in Harris County, which is located in Houston. Some of those judges make it required that you have mediation before a temporary orders hearing, but not necessarily for a trial.
Okay, so in Florida, if you're going to have a temporary motion that you're filing, you have to try to work it out with the other side and provide an affidavit saying that, you know, you've tried to, you know, work something out before you file a motion. But yes, as far as going to trial, you have to go to mediation prior.
That seems like a good thing, though.
It is. Most of our cases resolve without trial. And the only times that I've really gone to trial on things as if there's been some sort of domestic violence or violence towards a child, or where you have maybe like a mental health or some addiction issues, and you need a judge to look at it, because people who are addicted aren't going to agree that they need a substance abuse evaluation and clean drug test. They're not just going to agree to that off bat because they're struggling.
You mentioned something just now about drug testing. CPS, do they play a major role in some of the Florida cases that you worked on? It
just depends. I mean, I have a couple of cases where CPS has stepped in first, and that's how it got across to me on my desk. But no, if we are going to have somebody else step in, then it probably is a guardian ad litem or something like that. But a lot of times CPS isn't involved unless there's an issue that they have to be involved in.
For those who don't know what a guardian ad litem is, explain what that is.
Yeah, so it's an attorney that is supposed to be a non-biased party and specifically there for the child and the child's best interest. So they'll do a home study, they'll interview the parents, the teachers. If the child is going to like a psychologist or something of that nature, they'll talk to basically the child's community and help the judge to come to a decision on what's in the best interest of the child.
You mentioned the guardian ad litem. For those that are watching that don't have any clue what that means, what is a guardian ad litem?
It's a person that's appointed to the case. Sometimes it's an attorney, sometimes it's a person that has specific guardian ad litem training, but they're assigned to the case to figure out what the child's best interests are when it comes to time sharing, where the child is going to be throughout the year. So this guardian ad litem is interviewing teachers, psychologists, doing home studies to see where the child is living. And so they pretty much write a report and it assists the judge on determining what's in the best interest of the child for time sharing.
We have those a lot too in Texas. Most of the time in family law cases, especially the ones that I've seen in Dallas County, they are attorneys. Yeah.
For me, sometimes I prefer it to be an attorney. But I also do understand that, you know, if a person is highly trained to do this, then they should be just as competent. But I've had some bad outcomes too, so yeah.
Yeah, I've only had one case that I can remember where I disagree completely with the guardian ad litem. But other than that, they're usually great.
Well, for me, it's the cultural aspect of it.
Explain what you mean by that.
So, I mean, houses are run differently depending on what culture you're from.
Absolutely.
So, and even like if we were talking about black people, for example, there are different types of black people. You have people who are African American, who are Caribbean. The language that is used in different households, it might sound derogatory to somebody else, but it might be you just talking.
Okay, pause for a second. This right here is something most people don't realize about family court. Custody battles can be some of the most emotionally charged cases in the entire legal system. We're talking about parents, children, and deeply personal conflicts. When emotions run that high, it's not unusual for tensions to spill outside the courtroom, sometimes literally. Quick question for you watching. Do you think courts should have stricter security for family cases where emotions are already running this hot?
A certain way, and it's your culture. Even with the South, let's do North versus South. People in the South are pretty, known as being polite. You know what I'm saying? We're not going to be very direct and straightforward, but if you're talking to somebody from up north, they might be very direct, and you might deem that as being harsh when that's just their culture.
I've seen that a lot on the East Coast too.
Yes, definitely up and down the East Coast. So that's what I mean when I've had adverse situations with guardian ad litems, is they might not have been culturally competent.
Okay, that's a good point. When you are requesting that a judge appoint an ad litem, are you specifically asking them for someone who may be able to fit the criteria best for this family based on the cultural differences?
And that's where I have a little bit of an issue. So I've never specifically asked that, but if I have an issue with a guardian ad litem during trial, I might ask those things. Well, what do you know about this culture? How much time did you spend with each parent? Do you speak another language? If I'm handling a primarily Spanish-speaking case, do you speak Spanish? Did you translate something wrong? Did you take a translator with you when you did the home study? So if I have some issues with cultural competence, I make sure to bring those up to the judge, and judges are pretty, open to listening to your side as well.
That's a good point. That's a good point. Just to switch gears a little bit, we have grandparents' rights in Texas. They're very limited. Do you all have anything like that in Florida?
Yes, but they are limited as well.
Okay, all right.
Typically, if a grandparent is stepping in, it might be because a parent has passed away or a child doesn't, both parents have passed away. I've also seen it in cases where it might be a parent that's in the military. There's a loophole for time sharing to be done with their parents until they return back to the United States.
Really? Wow, that's
I actually
amazing.
established case law for Florida with that.
Good for you. Tell us about the case. You remember the case name?
I remember the name, but I can't give it.
Okay.
But yeah, so basically there's a loophole that if you're going to be temporarily stationed outside of the United States, like I said, your parents can step in to do time sharing. Well, as lawyers, the issue always comes down to words. What does temporary mean? Florida didn't have what temporary meant. So I looked up the military term for temporary. And it basically was, telling me what it meant. And Florida decided that was not the case. So they're like, if you're going to be stationed anywhere outside of 60 days, then your parents can't step in. Yeah.
Wow.
So the case was won on appeal. I won it on the trial level. So my client's parents were able to step in and have a good relationship with that child. But she filed an appeal and won it on the appellate level.
Oh, okay.
So grandparents didn't have any rights in that case. However, there is a great update. It was a very tumultuous case. This is the one I was telling you about where I almost quit practicing law. But now parents are doing extremely well, co-parenting beautifully. Grandparents are also allowed to be in this child's life, and she is just thriving.
That's wonderful. I love that for the child, because when you have a well-rounded system with a child right in the middle, they're going to thrive. They're going to flourish in anything that they want to do, because everybody is essentially working together for the child's best interest. I love that.
That village is very important. And you know what? The case that almost made me quit practicing law is actually the case that gives me hope. Because when I tell you police were involved, sheriff, we had to go find this child in the middle of the night. It was very crazy. But to now see a whole turnaround, it lets me know that even if clients come to me and they might not be in the best co-parenting situation, that if that can happen for that family, positive can happen for other families as well.
I love that. And I guess that's one of the reasons why I loved practicing law so much, is you can take a negative situation, I mean negative in every aspect of the word, right? And it can be turned around. You just have to have a ton of patience, obviously, as the legal practitioner. But it can happen.
It can. And I have one little thing that I think throws my clients off sometimes, but I prepare them when I go to trial for it. I want them, if there's a positive aspect of the other parent, say that positive aspect in court. it's going to make you look even better. Because now you're saying, okay, she might struggle, if I'm representing dad, mom might struggle in these certain areas, but she's really good at this or that. It's showing the judge that you're open to co-parenting well and that you do see positives. Most times in other cases, you just come in and, oh, he's doing that, she's doing that, and it's nothing positive. Well, y'all created a baby together, so something had to be good somewhere down the line, right?
Right. Absolutely. You know, I have an interesting situation that happened to me directly related to what you just said. I had the mom testify to the good things about dad because the judge that we were in front of in particular loves that. Absolutely love that, because you can go in and trash anyone.
Right.
You can find, if there is something negative to be found about a person, you can find it. And I had her testify to it. You have no idea. It was on Zoom. Not only her, but her friends and family that were watching, they were attacking me for making her say those things. Even my client was upset with me. All you're doing is have me on camera talk about how good of a dad he is, and that's why the judge ruled in his favor. Not realizing that the judge ruled in his favor because the law said that he had to.
Exactly.
But it didn't make you look like the villain.
Right.
You know, saying nice things about him. Because ultimately what I used to tell my clients is a child is comprised of 50% you, 50% the other parent.
Exactly.
That's 100% their identity. So if you're diminishing 50% of their identity, you're raising half of a person.
Exactly.
You're making them emotionally, physically, psychologically unstable. You know, so I think that's a good thing that you actually highlight that and have your clients say good things about the other parent.
Right, and on the flip side of what you were saying, I've been in trial sometimes, and when the other parent starts to hear something positive about them, it lightens the mood. Like, because they weren't expecting that.
I can see that.
Yeah, and so they're like, wait a minute. And so I will ask them on cross-examination, okay, you know, what can you say about my client that's positive? And if they can't say anything, that signals to the judge too, okay, we just got two people that don't like each other and can't co-parent because they're not even able to say anything positive.
It also makes the judge see who the problem is too.
Exactly. It's how everything we do is strategic, and I think sometimes people forget that. I'm not here to harm you. And at the end of the day, sometimes I will deal with my clients, but I'm thinking about that baby.
Right.
That's who I care about. Y'all are adults. Y'all are grown. Y'all have lived y'all's lives. This baby has to come up in this world. And if there's anything I can do to make that journey a little smoother, because we're already in the controversial, position, I'm going to do as much as I can. But let me back up for a second. You mentioned earlier in the podcast, if there was any clauses in Florida that y'all don't have in Texas.
Yes.
Do y'all have a disparaging clause?
Yes, we do, but
Okay.
you know, when it comes, we put them in the court order as injunctions.
Okay.
They're not really enforceable depending on how they're worded. Remember you mentioned about wording. Wording is very important with an
Yes.
injunction, because if it just says, which the most common way I've seen is, no disparaging remarks within the hearing or to the children about the other parent.
Yes.
Well, that within itself is not very enforceable. It has to be a little bit more specific to make it enforceable. So you all actually have disparagement clauses that are enforceable.
And I enforce them.
Oh, wow.
Once again, like I said, when you have a disrespectful parent, they will give you enough evidence of themselves. I can't tell you, I had one case where it was a black father and a mother who was a Latina. And she decided that she could call him the N-word whenever she wanted. Via text message in his face, no, you're not gonna do that. I brought that up in court, and that definitely was enforceable. That's disparagement. And if you're doing that in front of the children, causing scenes, now you're being I don't tolerate disrespect. I'm from Florida, like I said, we're a little wild and we're a little crazy, and we do not tolerate disrespect at all.
I hear that. So the hallmark in family law cases in Florida, if I'm catching the correct theme, is the best interest of the child.
Best interest of the child.
Same here in Texas.
All right.
All right. Well, Attorney Kyla Coleman, thank you so much
You're
for
welcome.
coming back a second time. Because again, I know the temperatures are a little different.
Yeah,
from
y'all
Florida.
have a real winter.
We do. I tell people all the time, in Dallas in particular, there are 4 seasons. And if you go somewhere like Houston, you may find 3. Because they skip right over fall a lot of times. I attended law school in Houston, and I wore summer clothes almost majority of the year.
Wow. And see, that's the thing too. It's clearly fall, and I done jumped to winter because it's so cold. Like I
Right.
can't, so I need to go find some warmth after that, some coffee.
You're so funny. Thank you again for coming. Thank you all for tuning in to our podcast. Remember to like, share, subscribe to the YouTube channel. Support Court with Judge Vonda B. I'll see you soon.